Welcome to Changing Higher Ed, a podcast dedicated to helping higher education leaders improve their institutions. My name is Dr. Drum McNaughton, and I'm the CEO of The Change Leader, a management consultancy that helps university leaders create sustainable higher ed institutions through holistic approaches to strategic management, university academics and operations, change management, leadership, and governance. Our podcast brings you the latest in higher ed news, as well as some of the top experts in our profession who will share with you their perspectives on how you can grow your institution. Our special guest today is Mike Goldstein of Cooley LLP. Mike's a pioneer in the development of the legal environment in higher education and a counselor at the highest levels of legislation in Washington. Mike founded the law firm Dow Loans in 1978, which in 2014 merged with the global law firm Cooley LLP, making Cooley Education the preeminent provider of sophisticated legal services, partnering with institutions, technology companies, and investors in every part of the broad education vertical. At Cooley, Mike leads a group of 20-plus lawyers and professionals with decades of experience in serving a wide range of clients, including public, independent, and for-profit institutions and the organizations that work with them. Mike has been a thought leader, an innovator, and a counselor to many of the most innovative developments in education, and he's played a significant role in the still ongoing efforts to harmonize education law with the seismic changes in how education is provided and received. We're glad he was able to take some time from his busy schedule to visit with us today. Hello, Mike. Good to have you on the show.
Well, good morning, Drum. I'm delighted to be here and look forward to a very interesting conversation.
Absolutely. We've been wanting to do this for a while. I'm really glad we've had a chance to get it together. And the timing seems to be really great. Last month, we finished up with the Neg Reg process having to do with accreditation and innovation. Let's just jump in right there. There were a lot of great things that came out of that. You're right there on the inside. What did you see?
It was a very interesting process. The Department of Education, Secretary DeVos announced quite some while ago that there was going to be a very broad negotiated rulemaking, Neg Reg is the abbreviation of that, that was going to look at essentially the fundamental rules that guide the way institutions interact with the Department of Education, with regard to the student aid programs and related elements. And what the Department of Education has done, and what really the Congress has done, is use access to federal student aid as a vehicle to bring a lot of aspects of higher education under some degree of federal supervision. And I guess the best example of that is accreditation, which is independent private organizations that work with institutions for the purpose of quality assurance. And when the Higher Education Act was passed back in the 1960s, Congress set up a three-legged stool to manage that process. The federal government would provide the money. The states would approve institutions. Institution has to be authorized by a state. And an institution would have to be accredited by an accrediting agency recognized by the Secretary of Education. Now, that sounded pretty straightforward, but what came out of that was a very extensive set of rules, particularly applied to the accreditors as to how they would go about their business in terms of assuring the quality of institutions sufficient to enable them to take part in the federal grant and loan program. And over the years, the accreditors have become, to a certain degree, subordinate to the Department of Education in terms of how they go about in doing their business. The negotiated rulemaking, and it was in this particular aspect, was titled Rulemaking on Accreditation and Innovation. And that's an important distinction of putting the term innovation in there, because accreditors have historically been accused of stifling innovation. And what Secretary DeVos and the acting undersecretary, Diane Howard-Jones, argued was that the rules should be changed to encourage innovation, and indeed what they were looking at was even encouraging competition among accrediting agencies. The rulemaking began not very long ago, a couple of months back, and to everyone's surprise, because it has almost never happened in a Department of Education rulemaking, the negotiators ended up with what is called a consensus. That is an agreement among all the parties negotiating. These were representatives of colleges, representatives of accrediting agencies, representatives of consumer groups, representatives of states. They came up with a consensus, and when consensus is reached, the law requires that the rule that is then published follows the consensus. The secretary does not have the discretion to then significantly change what was agreed upon. Now, that differs from where there was no consensus, where the secretary is then allowed to promulgate whatever rule he or she decides is appropriate. So we're at a very interesting inflection point with regard to the federal relationship with accrediting agencies.
Well, it certainly seems that way. And I guess an example of when they would not have come to consensus was the whole hullabaloo around Title IX. Is that true?
That's certainly the case. And another one that was not quite as contentious, but certainly that struck a lot of sparks was the negotiated rulemaking about what's called borrower defense to repayment. And that is a very, very brief statutory provision that's been in the law for a couple of decades, but really never used until the collapse of some of the very large for-profit school chains. And that provides that if a student believes that he or she was defrauded in getting their education, the student could apply to have his or her loan forgiven. And there were really no rules governing how that would be implemented. The Obama administration put in a very, very extensive, very complex legal framework for processing those loans. And the DeVos administration came up with an alternative strategy. No consensus was reached, and that is pending the issuance of new rules. There's a court case now that deals with that, and we may touch on that later in the program. But again, the striking example is the accreditation and innovation rules, in which we reached consensus, not we, but the negotiators reached consensus, and it has some very, very important provisions.
Well, let's talk a little bit about some of those provisions, because they are groundbreaking in many, many respects.
I think the part that is most interesting to me is the strong emphasis on new programmatic approaches, on new ways of delivery, a very, very strong message to the accreditors that rather than being penalized for thinking outside the box, which historically has been the way accreditors have felt they were being reviewed by the Department of Education, they are, under these new rules, they would be encouraged to seek innovative approaches to the faster, better, cheaper delivery of education. It was an interesting structure. The Undersecretary, Acting Undersecretary Diane Howard-Jones, I mentioned, floated some very aggressive ideas, but made it very clear that those were really kind of opening salvos to enable the negotiators to think outside the box and to come back with ideas that would creatively enhance the accreditation process as being innovative.
And that is in itself amazing, because normally when the Department of Ed puts something out, this is the way it's going to be, folks, and you have to listen. And from what I understand, Ms. Jones took a very different approach to that. She said, here's a target. Now let's see what we can work out. That's an amazing way to do something, and a good way to get it to consensus.
And it worked, which I must admit, to everyone's shock and amazement. And well, for example, that what the department proposed was with regard to something called contracting out. And that's the ability of an institution that's an accredited, authorized degree granting institution that participates in the federal student aid program to contract out all of a program to an entity that is not an accredited entity with the approval of its accrediting agency. So it could have a courseware provider, let's say Coursera, for example, provide an entire program. And as long as the accrediting agency said that that was acceptable, students enrolled in that program would be able to receive federal student aid. The negotiators pushed back on that, and the existing rule is that with accreditation approval, one can contract out half a program. That 50% limitation remained, but what changed was the requirement with regard to how that would be reviewed by the accreditors. And that the previous rule was that any action of that sort would be defined as what's called a substantive change. It would require a major review by the accrediting agency and action by its accrediting commission. The rule that was approved by the negotiators reduced that so that the accrediting agency merely needs to conduct what's called a staff review. So it does not require a formal commission action. It requires a relatively light review by the staff of the accrediting agency. Now that has two major effects. One of them is that it greatly simplifies the process. Far fewer trees have to die. What it also does is it probably reduces the time necessary from the point of proposing such an action to getting approval from many months to potentially a matter of a few weeks. And that is a very dramatic change, because part of what has inhibited innovation has just been the time and expense of going through the review process. So by making that process simpler and by making it clear that this is a favored kind of activity, I think that's going to open up a lot of opportunities for interaction between institutions and non-accredited providers of a wide variety of academic service.
I think you're absolutely right. And it's great that they came to that. The department initially had proposed 100% outsourcing, but I think that got knocked back by the participants back to the 50%, didn't it?
Yes, it got taken back to the existing 50%. So what changed was a very much procedural process that is much simpler than what the rules previously required.
And having put programs through the sub-change process, if you're approved for fast track, that's one thing, and that's usually just a staff review. But if it has to go to the full commission, with the timing, it's like you say, it could take 6 to 9 months to get something approved as simple as this.
Yeah, I think it is two effects. One is it will, I think, materially shorten the process. The other is it makes it very clear that rather than being an exception, this is actually a favored relationship, that institutions should be encouraged to reach out and make use of what's available among what have come to be called alternative providers. Line would be another example of that. And in many instances, these are less expensive, more efficient, substantively better ways of providing educational services than may necessarily be available within the institution.
And that makes perfect sense. I remember there was a huge hullabaloo when the MOOCs first came out, and that tended to be, it was blown up more than it was. But here now you have so many OPMs out there between Coursera, between 2U and others, and you've got others jumping into the game. There's no reason why course development and innovation shouldn't start to take more of a forefront.
I think that it really does shift the balance. And you're absolutely right. When MOOCs first appeared, when MITx was by no means the first massively open online course, it wasn't the first of those by any means, but it was the one that got the most notoriety. And it really changed the marketplace because the reaction was, well, if MIT can do it, then of course it has to be good. But the assumption was that was going to just radically change how higher education would be offered, and that there were those who said that the birth of the MOOCs marked the death of universities as we know them. Obviously, that death was greatly exaggerated. But what it has done is created a very substantial industry, and that is the right word, of companies that are using private capital to create quality educational experiences. And what this regulatory change will do will be to make it easier for institutions to pick and choose among those and make use of that as part of their educational program.
Which I think is going to be a great thing, because typically a faculty-developed course relies on the developer's expertise, their own research. It may not be as broad as it could be, and with outside people helping to develop, my sense is they're going to be far more current with what's going on. Of course, there's going to be those folks like Wiley and others who jump into this type of thing, Pearson, who want to highlight their own text. but that's not necessarily a bad thing considering that their text may be more up to date than some of the faculty stuff. So I think that's a good thing.
I think it cuts, in some respects, in the opposite direction as well, because it lets faculty be more creative. It lets academic departments and program directors and deans be more creative in looking at what is available in a much broader universe of educational services. And the existing rules essentially said, if it's not invented here, we can't really use it. What this is encouraging, other than buying a textbook, what this is doing now is it's saying, look, there is an enormous amount of material, program, information, educational services, different ways of delivering educational services that are out there in the marketplace. And if you're a program chair, if you're a dean, if you're a faculty member, you're now being given freedom, not direction, but freedom to look at what is the best opportunity, what is the best possible service. Two examples of that. One would be Straighterline that I mentioned before, which is an online. They're a online program manager. That's not quite the right term because they are effectively an educational program provider that focuses on the lower division undergraduate courses, English 101, Algebra 101, the core curriculum, the general education curriculum. That is a very expensive enterprise for a school to provide. And in most institutions, it is provided with very little innovation. It's there because it has to be there. And what Straighterline does is provides a way for institutions to offer that to students, particularly what we used to call non-traditional students, who are now the vast majority of college students, adult learners, an opportunity to deal with their general education requirements without having to go to the institution. So the institution can focus on those areas that it is most adept, that it has the best programs, the most innovative programs. That's a very important development. And the other side of that is enabling institutions to pick and choose among very specific, very complex programs that may be outside of its core capability, but nonetheless very valuable to what it's doing. An example would be what Trilogy Education Services is doing in providing coding courses, coding programs. And they are collaborating now with institutions from Harvard University all across the spectrum to provide that kind of educational experience that the schools don't necessarily want to provide or don't have the capacity to provide on their own. Harvard has an incredible computer science program, but they don't spend a lot of time training students in coding skills. The assumption is students may have that already. So there is, again, this great broadening of the market that I think this is going to encourage institutions to make greater use of that opportunity.
I think you're absolutely right, which kind of brings us to the next portion of one of the Neg Reg things is the credit hour and the innovation portion, like what Western Governors is doing with competency-based education. There were some new things that came out on both of those areas too, weren't there?
Yes, the very clear that the department wants to move away from the credit hour as the benchmark for all postsecondary education. The credit hour was created in the 1920s for determining the hours of work of elementary and secondary school teachers back when the first union agreements were being negotiated. And it got transported into higher education, and it became the coin of the realm standard that a course was 15 credit hours. A credit hours was 3 hours a week of instruction. And that then got transported in 1965 into the Higher Education Act. And remember, 1965, the touch-tone telephone was just coming into use. The internet was still almost 30, 40 years into the distance.
It was still in Al Gore's mind, right?
It was still deeply embedded in Al Gore's mind, and Al Gore was very young at the time. So what we're looking at now, and I think, again, what this accreditation innovation regulation is doing and some other regulations wrapped around it, is encouraging alternative ways of measuring student outcomes. So it's not just competency-based education, although that's a significant part of it. It's the notion that we're moving from measuring time and seat, which is what the credit hour does, to measuring what has the student actually learned. And the idea behind competency-based education and all of its variants, what we should be measuring and what we should be providing government support is what has the student learned? What is the outcome of the education? And the credit hour is a distant surrogate of that. Competency-based education and variants on it are much more direct in making that measurement. And Western Governors, Southern New Hampshire, a lot of institutions now, and some, not at all heralded, but still doing remarkably good work, are moving very rapidly in that direction.
And I think that's a good way to do it. I think what I'm hearing too is it's going to put far more emphasis on institutions doing assessment to make sure that students are in fact learning. Does that make sense?
Well, it really is focused on assessment, because the whole idea behind direct assessment is another aspect of it, is you're measuring what does the student, not what does the student know, like in a history exam, can you give me the date of the Battle of Hastings, but what competency has the student gained? Again, a history program, a history course, you're not looking at what fact has a student mastered, but what understanding of history has a student mastered? It's a difference between memory, and I guess the way to express that is the distinction between memory and mastery. And the credit hour naturally tilts towards measuring memory, and competency-based learning, direct assessment, tilts towards measuring mastery. One is an outcome, the latter, and the other is it's a skill, but it's a skill that really is separate from what does the student actually know? What can the student actually do with that knowledge?
It seems as though the credit hour is more geared toward the lower levels of Bloom's taxonomy, whereas assessment more toward the higher levels. Does that make sense?
Absolutely.
And so that's a major thing. I know another thing that came out of it was the definition of substantive interaction with faculty members, and that is going to be a major change as well.
That is a very, very important change, and that was connected with a proceeding that was brought by the Department of Education Inspector General against Western Governors University. And full disclosure, I worked on that proceeding on behalf of Western Governors University. And the argument that was made by the Inspector General was that the academic team that works with students as they progress through the academic program consisted of individuals other than traditional faculty. What the Inspector General said is that the law says that there has to be regular and substantive interaction between a student and faculty for a program to be considered appropriate for receipt of federal student aid funds. And the Inspector General said that interaction was not sufficient with regard to Western Governors, and Western Governors should pay back an amount of money slightly shy of $1 billion. That's billion with a B, which is a lot of money by any standard. And the argument made by Western Governors was that the government, in this case the Inspector General, is making a decision as to who is faculty, and that is a decision that should be made by the institution in collaboration with its accreditor. And the accreditor's view was that the team that worked with the Western Governors students were, in fact, all part of that broad definition of faculty. There was subject matter experts, there were learning experts, there were experts working with the student in terms of guiding the student through the academic process, not guidance simply in the sense of selecting courses, but guidance in the sense of the actual progress through the courses themselves. And what the rulemaking does is leaves to the institution and its accreditor the definition of who should be counted as part of faculty when one is defining regular and substantive interaction with students in a program that is other than face-to-face instruction. And that is a very, very dramatic change. And what that really does is says that finally, after a very long time of online learning being in existence, that you don't have to replicate a classroom with a teacher up front and the students in an array. You don't have to replicate that electronically for it to satisfy the regulation. What you have to create is an environment in which you can demonstrate that the students are learning, and you can demonstrate that the people who are participating in that process on the faculty side of the ledger are adding appropriately to that learning process.
That is absolutely huge. When I've looked at the things that have come out of the Neg Reg, that was the thing that struck me as is going to make the biggest difference for innovation in higher ed.
I think that's going to satisfy a lot of people that ideas that they have pushed to the back, waiting to see what would happen with the Western governors situation, that they're now going to move forward. Now, what's interesting is that there was almost, with the exception of the Inspector General, there was almost complete unanimity that Western governors was doing was right. And there was very strong support in the Congress on both sides of the aisle. There was strong support in the Department of Education at the level of the Office of the Secretary, and not just Diane Howard-Jones and Secretary DeVos, but Undersecretary Ted Mitchell when the Obama administration. But there was this concern that, well, the interpretation of the law, notwithstanding that everybody thinks it's a great idea, the interpretation of the law says it's not good. The combination of the decision by the Secretary and really embedding that in the rulemaking, I think, is going to open up opportunities for very, very creative kinds of team learning that will be of great benefits to students, to learners.
And as we move into new eras of education, and we're clearly getting there, this whole Neg Reg framework sets the direction and it opens it up so people can start doing more innovating. I think it's fabulous.
I think it's really a critical shift. One of the issues that I think we need to watch is that we've got really, in a sense, some conflicting tensions going on right now. We have a shift at the federal level and at institutions and accreditors, and I think in the marketplace, for a more dynamic, more open postsecondary system, one that is more learner-focused, one that is more focused on alternative opportunities, one that is looking at increasing partnerships between institutions and other entities. I was just at a conference on what's called P3, public-private partnerships, and great interest in moving in that direction. At the same time, there is a concern that this administration has loosened regulation and that institutions who may be bad actors are getting a free ride, or at least less rules being imposed on them. And what's happening is that some states are stepping in to fill what they see as a regulatory void. And it's actually, I think, more appropriate for the states to be the primary regulators of institutions. They're the ones who grant institutions authority to operate. The only actual role of the federal government is in providing the student aid. So it is appropriate for states to take an expanded role. But a lot of what we're seeing, and this is most pronounced in California, is a very reactive set of laws that have been proposed, not enacted, I want to emphasize, that could be very restrictive on some of the more innovative things that institutions are seeking to do. And that's a reaction to what is seen as a unwillingness on the part of the current Department of Education leadership to take a more directive role. I think we're going to see some bit of a tug of war now between what the states do and what the federal government does.
And I think that makes perfect sense. It really is up to the states to fill that regulatory vacuum, which is being left. And that was one of the points of contention initially starting with the Neg Reg, is that the state's attorney generals, who are responsible for the consumer protection were left out of the negotiating table.
Yeah, the attorneys general were not there. The state higher education officers were, and there was, in fact, an interaction with the attorneys general. So I think that problem was rectified. I think the consensus on accreditation and innovation, I think the states were satisfied with the process there. The other area that has arisen on this, a couple of lawsuits, the department has been compelled to put into effect the certain aspects of the state authorization rule that had been promulgated by the Obama administration, and that action was suspended on that. Enforcement was suspended by the DeVos administration. And the court said those rules have to go into effect. Now, the DeVos administration has proposed rules that are very similar, and they're primarily with regard to disclosing issues respecting professional licensure and whether programs are distance learning programs or students enrolled in a program can practice a licensed trade or profession in a given state, since they may be remote from where the institution is. Those rules, the court has now said, need to go into effect. The administration, I know from a recent conversation, is considering how to comply with that. But what is happening is the states have moved from focusing on authorizing institutions individually for distance learning, because that's been resolved largely by the State Authorization Reciprocity Agreement, SARA, the exception of California, which is not a member. But they're now focusing more on professional licensures. And that's an area that the regulation is supposed to require disclosure. There was a new regulation proposed that would go into effect on July 1 of 2020, And that rule is similar but different. So we're dealing with some conflict now between a rule that is required to go into effect and a rule that will go into effect. And there's a bit of a ping pong effect in terms of how the institutions are going to deal with that.
Well, this has been a huge summary, and we thank you very much. If there's three things that you would give, information you give to presidents on what they can expect going forward and how they need to take this information, what would that be?
Well, one would be to follow what is happening in negotiated rulemaking very closely and follow the implementation, because this is not something that should be dealt with by the student aid office, which is typically the only ones who worry about Department of Education rules. These are issues that go to the core academic functions of the institutions, and presidents and provosts and deans and program chairs all ought to be aware of the changes. They should be very aware of how accrediting agencies are responding to these changes. Some of them are going to be responding much more quickly than others. One of the issues that has come up is the differences in not just process and procedure, but really outlook of the various, particularly the regional accreditors. And that is true. And there is a need for schools to be aware not just of the general change in environment, but how their accrediting agency responds. That's the second. And the third, I think, is to really understand that higher education is very, very much in a dynamic state. Again, the thought that traditional higher education was going to go away and be replaced by something totally different and totally electronic, I think is wrong, certainly wrong in the foreseeable future. But what is happening and what has to happen is institutions have to change to accommodate to new learners and new learning opportunities and new markets and new demands by those markets, and particularly by employers. The rules are changing in favor of those opportunities. Institutions have to learn how to take advantage of them.
Those are three great ideas for presidents, and thank you, Mike. So from a personal note, what's next for you?
Well, we are very actively watching these changes. We're very actively involved in, as I mentioned before, the public-private partnership opportunities that are developing. There are a lot of large and small institutions that are looking to take advantage of partnerships with the non-institutional world to enable them to carry out their missions more effectively, more economically, more quickly. I think the notion of the ivory tower is really being replaced by, if you will, I guess the factory model of higher education. The students come in one end and pop out the other, clutching a degree and clutching a lot of debt, is being replaced by almost the notion of an educational village. And the institutions, the traditional institutions, are an important part of that village, but they're not the only part. And I think that's where certainly I'm devoting a lot of my attention.
Well, great. Well, Mike, thank you so much for being on the show here. It's been great, as always, to chat with you, and we look forward to the next time. Thanks for listening this week, and a special thank you to this week's special guest, Mike Goldstein, and giving us an update on the recent negotiated rulemaking process in D.C. Thanks, Mike. Always a pleasure, and look forward to having you on the show again. Our next guest is Deb Maui, a marketing and branding expert for higher ed, who'll be talking to us about the latest trends she's observing in higher ed marketing, positioning, and enrollment. If you like this podcast, please take a minute to subscribe to the show. And if you're listening on the Apple Podcast app, would you please take a moment to give us a rating and review? You can find out more information and show notes at changinghighered.com. And if you have guests and/or other topics you'd like to hear about, please email us at podcast@changinghighered.com to let us know. Remember, creating sustainable higher ed institutions requires three things: taking a holistic view of your institution, aligning strategies, structures, and processes, and ensuring stakeholders are attuned to where you're going. Without any of those three things, you won't get your institution where you want it to go. Until next time.